the 4th. So, Scholar Wale.
My lord, Kolawole is here. Ami Kolawole, sir.
You are for the claimant.
For claimants, yes, my lord.
A.O. Kolawole for the claimant. Yes, Mr. M.
M. Jimo, my lord.
M. Jimowit.
Alone, my lord.
Which?
For the first defendant.
Are you alone?
Yes, my lord. I'm alone now. For the first defendant. Thank you,
okay. Thank you. So this is my short ruling. So this is my short ruling. Oh. Okay, so this is my ruling. By a motion on notice dated and filed on the 8th of March 2022, the claimant praised this honorable court for the following orders. Number one, an order consolidating the following suits: NICN/LA/127/2019 to NICN/LA/16136/2019, NICN/LA/15/2021, NICN/LA/16/2021, and NICN/LA/17/2021. And for such further order or orders at this honorable court may deem fit to make in the circumstance. The grounds upon which the application is brought are stated as follows. Number one, that all claimants were employees of the defendant whose employments were terminated on the same day under the same condition. Number two, the defendant are the same in all the suits. Number three, the cause of action are the same in all the suits. Number four, the claimant items in all the suits are similar. Counsel the claimant file a 10-paragraph affidavit in support of the application wherein it was averred that all the claimants in the suit stated were employees of the defendant some time ago, and their employments were terminated the same day and under the same condition. The claimants in all the suits are claiming for their severance attachment against the defendants, hence having similar cause of action and claim. That all the suits can conveniently be heard simultaneously, and it will save judicial time and resources if the matters are consolidated. A written address was also filed wherein learned counsel to the claimant raised a loan issue for termination to it, and I quote, whether the claimant applicant is entitled to the praise sought by this application. Learned counsel submitted that by order 62 rule 17 of the National Industrial Court rules, the court may, on application, consolidate several actions pending before it, where it appears that the issues are the same and can be properly determined at the same time. Such in the case of vessel MB Sirius B and SCI Limited, and Ingeri and Okurukate. Council finally urged the court to grant the application. The first defendant respondents on 22nd of April 2022 filed a 9-paragraph counter affidavit in response to the claimant's application and filed a written address thereof. First defendant stated in his affidavit, in his counter affidavit, that the claimants are its former employees until 30th of September 2016, when they voluntarily ceased their employment and accepted new independent offers from Sanctuary Beverages and Food Limited. The claimants sometime in 2019 and 2021 individually instituted a separate suit against the first defendant claiming declaratory and monetary reliefs. There are several other suits instituted by former employees of the first defendant that are still pending before this court. It was averred by the first defendant that the reliefs claimed in the suit sought to be consolidated are not similar or uniform. The contracts of employment of the claimants in the suit sought to be consolidated are separate, distinct, and independent. Counsel the first defendant in his written address equally raised a loan issue for termination, thus the claimant applicant is entitled to the praise sought by this application. Counsel referred to paragraphs 2, 3, and 4 of the counter affidavit and submitted that the issues are not the same in all the suits of the claimants. Counsel cited the case of Ilobuchi and Ebipo. Counsel argued that the contract of employment of the claimants are distinct and different, and the defense put forward by the first defendant in all the suits are not similar. Hence, consolidation of the suit will only lead to confusion. The submission of counsel that individual differences in each of the suits will be noted and addressed separately during trial. In other words, evidence in one of the suits is not evidence in others, such in the case of A and FRN. Counsel contended that the claimant's intention to consolidate a total of 15 suits will be extremely difficult for the court to hear and determine at the same time. Counsel finally urged the court to refuse the application of the issues in the suit sought to be consolidated by the claimant are not similar, and the first defendant defense are not the same for all the suits. I have gone through all the processes filed by the parties and read the submissions of the respective counsel. In determining this application, I need to refer to Order 62, Rule 17, 1, and Rule 19 of the 2017 rules of this Honorable Court, which provide those, and I quote, the court may, on application, consolidate several actions pending before it, where it appears that the issues are the same in all actions, can therefore be properly tried and determined at the same time, unquote. Rule 19 also provides those, and I quote, an order to consolidate may be made where two or more actions are pending between the same claimant and the same defendant, or between the same claimant and different defendant, or between different claimants and the same defendant, or between different claimants and different defendants, unquote. It was held in Ingeri and Okurukate. The consolidation of actions is the process whereby two or more distinct actions pending in the same court have an order of court join and tried together at the same time. The action, though separate and distinct, are tried simultaneously in the same proceeding. Although consolidated actions are tried and determined in the same proceeding, each remains a separate and distinct action and has its own judgment given separately at the end of the common trial. It was held in Nasser and CHE Limited that the main purpose of consolidation is to save time and multiplicity of actions. In other words, the provisions for consolidation are meant to fast track and jumpstart the administration of justice, which is dotted with unwarranted delays in our legal system, though it will not usually be ordered unless there is some common questions of law or fact bearing sufficient importance in proportion to the rest of the subject matter of the actions, render it desirable that the whole should be disposed of at the same time. See the case of Lady Ju and Odulaja. It is imperative to state that the grant or refusal of an application for consideration is purely at the discretion of the court, and bearing in mind the fact that the claimants are former employees of the defendants some time ago, and their employments were terminated the same day and under the same condition, coupled with the fact that in other suits they are claiming for their severance entitlements against the defendant, then the suit can conveniently be heard together to speed up trial and save time and multiplicity of action. Accordingly, claimant's application for conciliation succeeds, and I hereby order for consideration of the following suits: NICN/LA/127/2019 to NICN/LA/136/2019 and NICN/LA/15/2021 to NICN/LA/17/2021 respectively. Yes. Kolawale.
My Lord, we are grateful for the well-considered ruling, sir.
Thank you.
We thank my Lord for the time devoted to the ruling. But my Lord, there is one. Yes, my Lord. My Lord,
your other keystone matter.
Yes, my Lord.
It's not yet ready, but I'm going to send the hearing notice to you.
My Lord, we are grateful.
Keystone matter is for amendment.
Yes, my Lord.
So what do you do now?
My Lord, these cases consolidated. There is one order that we moved together with them that day. I think it's 236. They came together. I humbly pray that we be given dates for trial.
For trial?
Yes, my Lord. Pleadings have been completed, I guess. Mujib.
Are you not going to do anything? I don't know.
No, my Lord, we have completed pleadings. As far as I'm 15 to 17. Mujib, Alpha.
Yes, it has been completed.
So, which dates?
My Lord, we'll take
the other ones were adjourned to when?
My Lord, it was adjourned to the same dates with these ones.
No, I mean the other ones, the other cases where it's like there are okay. Okay. No, but you still have some now.
My Lord, those other ones that proceeded to trial, it was only remaining defense in those ones.
Okay, let me call Hajia and so that we'll.
Yes, madam.
So that she give us the date.
I don't know whether 25th July will be convenient to the court, sir.
GSK matter.
Okay.
So what date are you giving us?
What are we adjourning for, my Lord?
They asked for a date for hearing, for trial.
My Lord, December 15 will be better.
Ajia.
December 15. For all the cases.
My Lord, sir. I have some cases there already.
Just hold on, Mr. Lawrence, hold on.
Just call me tomorrow. I will check where I can put it.
Okay.
Okay, but on December 13th, you have only one matter for December 13th.
13th of December. You know, we are going to have many GSK matters on that date.
This is the one that are coming for sale. They are using one as the test. So we have put it on December 13th.
Okay.
So all other ones, all of them cannot be in a day.
Okay, 13th of December.
Yes.
Mr. Jimo, is that
Another
okay?
Aja is not aware. Another Aja is not aware of the ruling of this court that we are consolidating. She's not aware. Maybe she's afraid that we are spreading them one by one.
Aja.
I know. My lord, you are using one as test case. That's why. So whether consolidating or not, 13th of December.
You know, Kulawala, there is so choked.
My lord, we will take the 13th.
Yes, Mr. Mujib, is that okay?
Yes, it is okay, my lord.
Okay.
There is something I would like to raise, my lord. So
Yes.
it is with respect to.
Thank you, Ajia. Yes.
Okay, that's fine.
Yes, Mr. Mujib.
With respect to your direction at the last proceedings, that after the ruling, then the court would direct the parties on how to proceed with the consolidated suit.
No, but that's the problem of the claimant. I don't want to go into that, Mr. Jimo. Is their case, in whatever way they choose to go with their case, let them do it.
Very well, my lord.
Yes, but it's like Kulawale.
My lord.
It's like there are still some pending applications, but
yes, my lord. If there is any on that thing,
is it in one of the cases, in one of the conciliatory cases, or is in a different matter?
My lord, I'm not even aware of any pending application.
In the other conciliatory matters, there's no any pending application.
I didn't file any.
Okay, but on the last agenda, it's like there was a counsel representing the second defendant. Is that right?
No, not in this case, sir.
Okay, not in this case.
The case of the defense is that the two names, the first defendant's name and the second defendant's name, is being used by the company.
Okay.
So there is strictly speaking no second defendant in existence. It is still the same person using the two names at various times. So the only registered name, according to the evidence I've gathered so far, is the first defendant.
No, but there is still a counsel representing the second, like in the.
So my lord, we never had.
No. So it is possible that the case my lord is referring to is involving some
two counsel cross-examined your witnesses that you.
Yes, so
my lord, those ones are Suntory 1 and 2. They have GSK 1, they have Suntory 2. Those ones are standing alone.
Okay.
Yes, my lord. My lord, this 236 was moved from its trial date alongside with these matters consolidated.
Okay, you should tell Hajia to also fix it on that same 13th of December.
My lord, we are grateful, sir.
Thank you so much. As adjourned 13th of December 2022 for trial.
As the court pleases. My lord, we are grateful.
Thank you. So, Mr. Lawrence and Alamu.
Good evening, my lord.
Thank you. So, Mr. Lawrence. Yeah, Mr. Oluole Alamu.
Yes, my lord. I appear for the defendant.
Okay. But before I deliver the judgment, Mr. Lawrence.
My lord?
Mr. Lawrence, can you hear me?
Yes, my lord.
In your statement of fact,
Yes, sir.
you've asked for 3,135,000 naira as severance benefit.
Okay, yeah.
How did you arrive at that?
It's unfortunate I said that, but I think it's basically 22% or so of per month.
No,
times
no,
the number of-
30% of of monthly salary.
Yes, sir.
Times 2 years.
Times the year. Yeah, times the year.
How much would it give you? How much would that give you?
I think that must have been 3.1 something, 3.150 or so.
Then what is 30% of the monthly salary?
30% will be, because the last monthly salary is 95,000. 30%, 95,000, 95.
Then 30% of 95,000 is at 31,600 and something, 660 naira. Yes.
31, 32,000.
So that one would be times 22 years. Is it times 22 years?
So times 12 times 20. No, times, I think it's what I can't remember.
If it is times 12 times 22, it's going to give you around 8 million naira.
Oh, okay. My mistake.
So let me just.
That, my lord. I appreciate that, my lord. My mistake. I made that mistake.
Let me just deliver
That was the intention. 31 or 32 naira times 2,000 times 12 times 22.
If that's the one, that will give you around 8 million naira.
Okay, because I'm driving now, I can't do that computation.
Mr. Alamu?
Yes, my lord.
Isn't that so that 31,666 naira times 12 times 22 years?
No, my lord. My lord, there are two laws involved.
Yes.
The Initial Pension Act and
Yes,
the
I know.
latter one.
Yes.
Yes, my lord. The percentages that is payable are different. So we cannot do a blanket 22 years multiplication.
Yes, I understand. I understand. It's okay. Let me just deliver the rule.
We did even the salary of the claimant has not been the same for 22 years.
Yes.
It was progressing
It started
over time.
from 45 in 1997.
Yes, my lord. We did a detailed.
Yes, it's okay. It's okay. Let me just read the judgment, Mr. So this is my judgment.
As God pleases.
The claimant commenced this suit by a complaint and other accompanying processes filed on the 15th of July 2019 and asked for the following reliefs as contained in assessment of fact against the defendant. Number one, a declaration that the claimant is entitled to a tax credit, registration and payment of pension, payment for health management organization for our family, leave bonus for 2015 to 2019, and 20% meritorious service allowance. Number two, a declaration that the claimant is entitled to remain in the premises allocated to her until she is paid her full entitlement. Number three, an order of award of 3,135,000 being gratuity entitlement of the claimant from the defendant. Number 4, an order of award of 2,200,000 naira being the amount representing health provision for the claimant's family for over 22 years. Number 5, an order of court, an order of 1,006,000 naira being the amount payable under the pension scheme by the defendant to responsible pension administrator. Number 6, an order of award of 212,000 naira being unpaid leave allowance between 2015 and 2019. Number 7, an order of award of 20% meritorious service allowance of 387,200 naira as specified by the defendant but not paid. Number 8, an order of award of 1 million naira being the cost of prosecuting this suit. The defendant, upon being served with the claimant's suit and in reaction to same, file its memorandum of appearance and statement of defense via leave of court granted on the 14th of November 2019. Case of the claimant. From the pleadings filed by the claimant, her case is that she was employed by the defendant on 24th of July 1997 and worked for 22 years without any blemish. That she was promoted to the position of general manager but resigned on 25th of January 2019 on personal grounds. That based on the letter sent to her by the defendant, she is entitled to the sum of 3,135,000 naira as a gratuity, but she was not paid by the defendant. Claimant also about that she is entitled to 2,200,000 naira being the amount representing health provision for her family for over 22 years. She also asked for a sum of 1,006,000 naira being the amount payable under the pension scheme by the defendant, which shall be paid to a responsible pension administrator. Claimant also stated that her leave allowance of 212,000 naira between 2015 and 2019 was not paid by the defendant. A sum of 387,200 naira as 20% meritorious service allowance and 1 million naira being the cost of prosecuting this action was also claimed by the claimant. It's also the case of the claimant that she was given an official car which had bad engine and a plot of land along with some other stuff as compensation for long service award. The land and vehicle given to the claimant was never part of her pension plan. The one the defendant indicated no interest in repairing the said vehicle. The one the defendant indicated no interest in repairing the said vehicle, the claimant repaired the vehicle at the cost of 263,900 naira. The claimant occupies the defendant premises, which the defendant has been deducting rent from the claimant's salary. However, the defendant threatened to eject the claimant from the said premises. Case of the defendant in the statement of defense stated that the claimant is not entitled to the sum of 3,135,000 naira as a gratuity. To the defendant, it is inconceivable that the claimant who said her salary was 95,000 naira could afford to pay her lawyer the sum of 1 million naira as solicitor's fee. Now, the defendant did not at any point in time deduct 20% of the claimant's annual salary from meritorious service allowance. The offer of meritorious service at the rate of 20% of the annual salary to its outgoing employees is self-funded by the defendant and strictly at the discretion of the defendant, who determines which employee deserves such allowance. The defendant did not consider the claimant as deserving to be given the said allowance as expressed in the letter of acceptance of resignation. The defendant stated that it made bulk payment of the taxes of its employees to the appropriate tax authority, and the state tax authority did not at any time issue individual tax receipts or cards for the employees of the defendant because of the bulk method of payment of the taxes. The claimant was only entitled to free medical services for herself alone at the defendant's clinic, but the medical services did not cover members of her family. It was stated that the defendant did not initiate any pension program with pension fund administrators because it had a better alternative pension plans for its employees. That the vehicle and the plot of land given to the claimant was an alternative to the pension contributions payable on behalf of the claimant. Trial. Trial in this case commenced on the 24th of June 2021, while the claimant testified as CW1. She adopted her two witnesses on August 15 July 2019 and 4th October 2019, respectively, and turned the following documents as exhibit. Appointment letter exhibit C1, C2, C3, C4, up to C14. The claimant was thereafter cross-examined by the learned counsel to the defendant, and after re-examination, the case for the claimant was closed. The defendant called Mr. Festus Oni, DW1, as its witness. He adopted his statement on oath dated 18th of September 2019. DW1 was cross-examined by the claimant's counsel, and as there was no re-examination, DW1 was discharged and the matter was adjourned for addition of final written addresses. Defendant's address. The defendant's final written address, which was filed on the 10th of November 2021, contains one issue for determination to it, and I quote, without the evidence the claimant has proved with sufficient evidence before the court each of the claims as she's seeking in this suit. The Learned Counsel on behalf of the defendant submitted that the burden of proof is on the claimant to establish that she's entitled to each of her claims being sought in this court, citing sections 131 and 132 of the Evidence Act on the case of Wike and Dakuku. Counsel submitted also that the statement on oath of the claimant was silent on her entitlement to tax credit, as claimed in paragraph A of the reliefs being sought. The claimant left the court to speculate on her entitlement to tax credit. There was no specific figure and dates given by the claimant to show the reductions made by the defendant to warrant that she's entitled to tax credit being claimed. Counsel contended with regards to the claim for payment of medical allowance for the claimant's family that there was no evidence before the court to show that she has a family on behalf of whom she is making the claim. That under cross-examination, the claimant admitted that letter of employment XBC1, by a letter of employment XBC1, she was only entitled to free medical services at the company's expense for herself alone, excluding members of her family. That she enjoyed free medical services while in the employment of the defendant. To the further submission contention of counsel that the claimant is not entitled to remain in the premises allocated to her until she is paid her full entitlement on the grounds that by Exhibit C8, the tenancy only subsists if the claimant remains in the employment of the defendant, and that the claimant in Exhibit C6 pleaded with the defendant to be given till June 2019 to vacate the official accommodation. Citing Section 169 of the Evidence Act, according to counsel, the conduct of the claimant in failing to use her official accommodation after resignation from the defendant's company for over 2 years amounts to self-help, an exercise that has been condemned by courts. Submission of counsel that the claim for award of 3,135,000 naira being gratuity entitlement of the claimant from the defendant speculative and unfounded, as Exhibit C3 does not in any way support the assertion of the claimant. Another counsel urged the court to dismiss the gratuity entitlement of the claimant against the defendant, and also to dismiss the claim of 2,200,000 naira being the amount representing health provision for the claimant's family for 22 years. Counsel further submitted that there is no evidence of actual amount payable with regards to the claimant's claim for an award of 1,006,000 naira being the amount payable under the pension scheme by the defendant. Counsel argued that the applicable laws regarding the quantum payable as pension contribution on behalf of the claimant are the Pension Reform Acts of 2004 and 2014, respectively, and that both acts are not retrospective in nature and do not cover the period of the claimant's employment of the defendant prior to the enactment of the two acts. According to the counsel, the total pension contribution payable by the defendant on behalf of the claimant between January 2004 to January 2019 is 803,875 naira. Only taking into consideration that the claimant had received material benefits of car and a parcel of land, though disputed, as alternative pension plan for the claimant. Council submitted that the claim for the award of 212,000 naira unpaid leave allowance between 2015 and 2019 should be dismissed. It is submission of council that the claim for 307,200 naira for meritorious allowance as claimed by the claimant ought to be dismissed, as she cannot be allowed to approbate or reprobate at the same time. The issue of payment of meritorious service allowance is at the discretion of the claimant and not mandatory as exercised by the defendant in Exhibit C3. The defendant's counsel, the entire claims of the claimant, that of the 1 million naira at the cost of prosecuting the suit should also be dismissed, save and except the sum of 803,875 naira admitted by the defendant as contribution payable by the defendant on behalf of the claimant under the contribution pension scheme between 2004 and 2019. Claimant's final address. Claimant's final address was filed on the 6th of December 2021, where Learned Counsel for the claimant submitted 3 issues for determination to it. Court, whether the claimant is entitled to the claims before the court. Number 2, whether the gifts or emoluments that were given to the claimant whilst in service to celebrate milestone is recoverable. Number C, whether the claimant has suffered by not receiving her entitlement and ought to be paid damages. Counsel submitted that the claimant, as a former staff of the defendant who worked for 22 years, is entitled to gratuity, pension fund, unpaid leave allowance, tax credit, medical allowance for her family, a meritorious service award of 212,000 naira. Counsel also submitted that the claimant's evidence before the court was not successfully countered under cross-examination or in the defendant's defense, citing the cases of Anderson and Nalbasan Bank, KD Ventures Limited, and Honorable Minister FCT. It was also submitted that evidence as not challenged or controverted to be read and acted upon by the court, citing the case of SPDC Nigeria Limited and Idigbe. Submitting further, counsel argued that the defendant's sole witness admitted under cross-examination there is no evidence, oral or documentary, that the claimant was informed that the gifts given to her were alternative to pension arrangement as required by law. The Idigbe one was also admitted that he was given 3 cars by the defendant, and none of them was an alternative to his pension scheme. That he also admitted that the plot of land in question was given to the claimant in 2017 as part of a series of gifts given to staff. The claimant spent 20 years as a staff as at that time. Learned Counsel, based on the above argument, contended that the defendant should be stopped from denying that the gifts given to the claimant are not part of her pension. Also referred to Section 116 of the Evidence Act and the case of Koka and Odushota, IGA and Amakri, Udia and Usuji, Bozin and the state. Learned Counsel further contended on behalf of the claimant that the defendant company could not have quantified the value of the claimant's entitlement 2 years before she resigned. Counsel cited the case of Kato and CBN. Counsel posted that the claimant has given evidence that the knocked car was a gift, and she provided a receipt of the repairs. And as regards the plot of land, she presented 20 years service plus award. The defendant failed to show any evidence to prove that the gift were part of the claimant's pension scheme. And the position of the law is that where issues are joined and no evidence is produced, averment must be struck out in relation to the party that failed and neglected to provide evidence is averment, citing the case of Omobo, Rio, and Ajasin. It is considered that the damage done to the claimant by the action of the defendant is undue withholding of her entitlement despite being aware that she was not going to take up another job and preventing her from accessing 25% of her pension fund, having been out of job for about 2 years now. Citing the case of ELF, Petroleum Limited, and AMA. Counsel stated that it was reasonable for the defendant to ask the claimant for evidence of tax credit. The claimant cannot in any way approach the state government for any matter for those years, as she cannot show proof of tax payment for those 20 years. Counsel further stated a response to the defendant's final address that the claimant's leave bonus is not in doubt, and the defendant did not deny at any point during the trial or in his pleadings that the leave bonus is stated in the claimant's letter of employment. Counsel finally urged the court to grant the claimant's claims. I've carefully studied the pleadings filed by the parties and the evidence presented, having also considered the submission of the respective counsel for the parties. The issue I find suitable to address is whether the claimant is entitled to the reliefs claimed. The grounds of the claimant is that she was employed by the defendant and worked for 22 years without any blemish, that she was also promoted to the position of general manager, and after her resignation, she is entitled to a gratuity and some other benefits which were denied by the defendant. Claimant thus asked for some declaratory reliefs and monetary claims. Claimant's first relief is for a declaration that she is entitled to a tax credit, restoration and payment of pension, payment for health management organization for her family, leave bonus for 2015-2029, and 20% meritorious service allowance. The defendant in paragraphs 6, 7, and 8 of the statement of defense stated that all tax deductions from the claimant's salaries along with other employees were remitted by the defendant to the appropriate tax authority. But because of the bulk method of payment, the said tax authority did not issue individual tax receipts or individual cards for the defendant's employees. It is undoubtedly clear from the above that the defendant made the deductions and remitted same to the appropriate tax authority. But the defendant's only excuse is that the said authority did not issue individual receipts or cards. It is strict principle of law of evidence that facts admitted need not be proved. In determining, therefore, on whom lies the burden of proving any fact in issue, it must constantly be borne in mind that no onus lies on the party whose allegation of fact is admitted by the other party. This is so because in law, facts admitted need no further proof, as admission is perhaps one of the strongest forms of evidence available in any proceedings between the parties in the case. See the case of Keno, Madina, Tal, and Abdullah Shaibu. In the light of the above, I hold that the claimant is entitled to a tax cards or receipts from the defendant. For the claimant's claim for payment of health management organization for a family, it is clearly evident, as stated in XBC, that free medical services are only provided for a staff. CW1's testimony under cross-examination is apt, and this is what she said, and I quote, yes, by virtue of clause number 2 of XBC1, the free medical services was only for me and not any dependent, unquote. In the absence of any documents conferring that entitlement on the family of the claimant, coupled with the fact that, coupled with the admission of the of the claimant under cross-examination, the claim for payment of health management organization for the claimant's family is refused. Claimant has also asked for a declaration that she's entitled to remain in the premises allocated to her until she is paid her full entitlement. It is tried that declaratory reliefs must be strictly pleaded and proved by credible evidence, which has to be laid and proffered by the claimant to suspicion and discretion of the court. Declarations are equitable reliefs, and so the parties seeking such declarations must present the materials upon which the court will act to so declare. See the case of Akande and Adisa, AG Federation and AG Cross River State, Buhari and Obasanjo, INEC and CPC. It can be observed that the claimant in XBC 6 pleaded to the managing director of the defendant to give her up till June 2019 to move out of the premises. It was similarly stated in XBC 8, particularly paragraphs 2 and 12, that the tenancy created shall subsist on the condition that the claimant remains in the employment of the defendant, and upon resignation or termination of the claimant's employment of the defendant, the claimant shall vacate and deliver up vacant possession of the premises to the landlord. Flowing from the above, and given the fact that since the claimant by XBC 2 and C3 has resigned from the defendant company, then the claimant's relief number 2 ought to be dismissed, and I so order. Claimant's remaining reliefs are monetary in nature, hence a claim for special damages, and the claimant therefore bears the risk to prove her specific claims. The claimant, in trying to prove her entitlement, presented her offer of appointment, acceptance of her resignation letter, and her solicitor's letter, Exhibit C1, C2, and C3 respectively. In the claimant's offer of appointment, Exhibit C1, it was the claimant's salary of 1997 that was stated, and the medical services to be provided was only restricted to the claimant. It was also provided in Exhibit C1 that the claimant is entitled to 5% of basic salary as leave allowance. Claimant has also, in a solicitor's letter, Exhibit 10, stated and claimed for several benefits contrary to what the defendant stated in his letter of acceptance of resignation, Exhibit C3. By the provisions of Section 131 of the Evidence Act, it is the duty of the claimant who assert the existence of a legal right that must prove that those facts exist. In the case of VP Industries Limited and Coca Industries Limited, the court held that the burden of proof in all cases rests on the person who asserts. The claimant is required by law to plead and support what she has pleaded by credible and convincing evidence, and that evidence should preponderate in civil matters before her claims can be acceded to by the court. And while she fails to discharge the honors, her claim must fail. See the case of Hamza and Kuri. To prove an entitlement, as in the instance case, the claimant must refer the court to the exact provision of the law, instrument, or document that confer the entitlement. See the case of Mohammed, Dungus, and Consortium Limited. I need to observe here that there is no document or instrument presented by the claimant that has fully and comprehensively conferred the entitlement claimed by the claimant. The claimant in paragraph 13 of her statement of fact alleged that there was never a handbook for the dependent company. Exhibit C10 written by the claimant solicitors. Claimant shows some figures, but it is not stated how the claimant came about the said figures and all entitlements. Meanwhile, Exhibit C1 only contains claimant's salary of 1997 and provision for medical services and 5% of basic salary as leave allowance. And again, Exhibit C3 states that the claimant's total benefits is 598,500 naira, less 448,500 naira as unauthorized collection of money by the claimant from the defendant cashier. It also states, it also shows non-cash gifts of Toyota Camry and plot of land that the claimant has forfeited, that the claimant has forfeited 20% meritorious service allowance for inappropriate resignation. Claimant in paragraph 10 of her statement of fact avowed that based on Exhibit C3, she's entitled to 3,135,000 naira, being 30% of her monthly salary of 95,000 naira, of 95,500 naira, of 95,000 naira for 22 years. In paragraph 14C of the statement of fact, claimant also particularized her salary from 1997 to the time she resigned from the defendant company. But throughout the entire process before me, there's no document that shows how much was the salary of the claimant, save Exhibit C1, which only shows her basic salary and leave allowance of 1997. Essentially, claimant's claim is anchored on Exhibit C3, and her claims to naturally be granted on that exhibit, and probably by the admission made by the defendant in its pleading. According to Exhibit C3, the following are the claimant's severance benefits as calculated in accordance with the company's policy. Number of years, 1998 to 2019, 21 years, benefits, 30% on monthly salary, 28,500 naira times 21. which will give you 598,000 naira, 598,500 naira, less unauthorized collection of money from the cashier for recharge cards, fuel transport, vehicle maintenance, data bundle, 150,000 naira, total benefit, 448,000 naira, 448,500 naira. Other non-cash benefits, company's car Toyota Camry, number 2 plot of land at Moi allocated. It's also providing Exhibit C3 that the claimants forfeited 20% meritorious service allowance because she did not resign appropriately. Finally, in paragraphs 15 and 18 of the statement of defense has particularized the salaries of the claimant from 2004-2019 and stated that the total pension contribution payable by the defendant at all material terms from January 2004 to January 2019 is 803,875 naira. The defendant has also, in paragraph 2 of its statement of defense, stated that the total leave bonus due to the claimant from the defendant between January 2014 and January 2019 is 145,475 naira. However, the claimant in his reply to the statement of defense admitted paragraphs 13 to 17 of the statement of defense, but denied paragraphs 18 to 22 of the said defense without more. I have noted earlier that in proving an entitlement, as in the instance case, the claimant must refer the court the exact instrument or document that confer the entitlement. In the entire documents presented by the claimant, aside from the abandonment of the claimant in assessment of fact and the admission of the defendant, there is no document like pay slip or bank statement of account that shows the claimant's salaries from 1998 to 2019. Suffice it to say that mere abandonment without evidence to buttress him goes to no issue. In any event, I'll go by the admission made by the defendant in paragraphs 18 and 22 of his statement of defense that the total pension contribution payable by the defendant from January 2004 to 2019 is 893,875 naira, and the total leave bonus due to the claimant between January 2014 and January 2019 is 145,475 naira. I accept the above admission as evidence against the defendant and accordingly find and declare that the claimant is entitled to a pension and leave allowance without any conditions sought to be attached by the defendant as per paragraphs 18 and 22 of the statement of defense. The point has earlier been made, and which still remains the law, that facts admitted need no further proof, as admission is perhaps one of the strongest forms of evidence available in any proceedings between the parties in the court. See the case of Madinatal and Abdullah Shuaibu Supra. The defendant has contended that it did not initiate any pension program with pension fund administrators because it had a better alternative pension plans for its employees. Hence, the Toyota Camry and the plot of land given to the claimant was an alternative to the pension contribution payable on behalf of the claimant. On the contrary, claimant stated that she approached the managing director of the defendant to allow her to take the Toyota Camry, and when he indicated no interest in repairing the car, she repaired the same vehicle with her personal funds at the sum of 298,000 naira. And upon clocking 20 years with the defendant, she was given a plot of land along with some other staff who were given varying degrees of gift as commensurate to the years of service to the defendant. I need to state that in the absence of any express agreement favoring the weaker party between the parties in the instance case, to exclude the provision of the Pension Reform Act with regards to the payment of pension, I will not agree with the condition of the defendant that the gift of Toyota Camry and a plot of land to the claimant was part of any pension plan. I therefore reject the said contention. On the claim for 20% meritorious service allowance, defendant has averred that said allowance is self-funded by the defendant and strictly at its discretion. Hence, the defendant did not consider the claimant as deserving to be given the said allowance as expressed in the letter of acceptance of resignation. I find that there is no evidence from the side of the claimant that the defendant had made that reduction from her salary. There is no evidence as well that the claimant is entitled to the said allowance as of right. Therefore, the claim for 20% meritorious service allowance is refused and is accordingly dismissed. It now remains the claim for 3,135,000 naira being gratuity of the claimant. I have noted earlier that the claimant in paragraph 10 of her statement of fact about that she's entitled to this sum based on exhibit C3 being 30% of her monthly salary of 95,000 naira for 22 years. To the contrary, the said exhibit C3 said that the claimant benefits is 598,500 naira, being 30% of monthly salary, 28,500 times 21. I've not been able to see from the claimant's pleadings how the sum of 3,135,000 naira was arrived at. From my little knowledge of simple arithmetic, 30% of 12,000 naira will be around 31,660 naira, and the said 31,000 multiplied by 22 would be 606,652 naira. But if it is 31,616 naira times 12 times 22, the result will be 8,359,202 naira. I should say that as a result of this seeming uncertainty and inconsistency, the claimant has not been able to prove his gratuity claim of 3,135,000 naira or 135,000 naira. However, the severance benefit based on XPC 3 and based on the fact as well that the claimant worked for 22 years will then simply be 31,666 naira times 2 years instead of 21 years as alleged by the defendant. In the light of all the above and for the reasons stated so far, claimant's case only succeeds in part. And for the avoidance of doubt, I make the following declaration and orders as follows. Number one, it is declared that the claimant is entitled to a tax credit, registration and payment of pension. Number two, that the claimant shall be paid the sum of 803,875 naira by the defendant as a pension contribution from January 2004 to January 2019. Number three, that the claimant shall also be paid the sum of 145,475 naira by the defendant as leave bonus due to her between January 2014 to January 2019. Number four, that the defendant is ordered to pay the claimant her gratuity severance benefits in the sum of 606 naira, 602,652 naira. Claimant's relief to remain in the premises allocated to her until she is paid her full entitlement is refused. Claimant's relief for health provision for her family for 2 years, and I claim for 20% meritorious service allowance and cost of prosecuting this suit are also refused and accordingly dismissed. The judgment sum shall be paid within 30 days from today, failing which it shall attract 10% interest per annum until it is fully liquidated. Yes, Mr.
My Lord, we are grateful for the judgment. We are quite taken aback by some part of it, but it is what it is. We will sit down and analyze. We didn't know that the admission by the defendants or even the little we provided will not. But we are grateful, sir. We are grateful for the judgment. We will do the needful. We are grateful, sir.
There is no any document concerning any of the entitlements.
My lord, I'm not going to argue with you, my lord, but I just know
Yes,
that if a claim is before the court and the defendant does not credit the claim to the extent of saying, okay, she didn't work for us, I think by law.
No, it's not the matter of somebody didn't work for you. It's the matter of proof. Even if somebody worked for you and you are claiming for entitlement, special damages, it has to be strictly proved and pleaded. You have to strictly prove your entitlement. If somebody is saying that my gratuity is so and so, you should come up with an instrument saying that yes, this is what somebody should be paid after his service. Company handbook. There's no handbook. There's no any document.
My lord, if the defendant is being allowed to benefit from its wrong because he never has an handbook.
No. You see, the thing is that it is for the claimant to prove his case.
There's no handbook actually. There was never any.
Even if there's no handbook, if you are saying that this is my salary, how are you being paid? How is the claimant being paid? Isn't it through bank?
Yes.
So she don't even the salary of 12,000 naira without the admission of the defendant. How can the court find that the salary of the claimant is actually 12,000 naira?
We are just. I appreciate my lord's engagement, and it's quite appreciated.
Yes.
We will look at it, and
the claimant should have done more.
The claimant, my lord, if I agree, even if my lord says, "Oh, the claimant should have done more," I thought the courts in Nigeria. I was in before Justice Ogunfa till late, and that's why I'm joining this late.
Okay,
all we said we got is the feeling we are getting from judges in Nigeria is that technicality. Yes, they are disturbing me.
She shouldn't be allowed to defeat substantial justice.
What we thought, sir. And if I was made to download the NICN app today.
Yes.
So technically, I had to then see. It said to be the motor said to be bastion of labor justice.
Yes.
We would have thought that my lord would have
just gone ahead and
no. I would have thought my lord would have considered part of the claim. If a person says, "I worked for a person and I'm not paid my entitlement," I'm not sure for maybe 1 year or whatever. I'm not sure there should be a better ground for what is it called now? Damages. They say, okay, that's a damage to me because.
Okay, but how much is that entitlement? How much is the entitlement?
That's actually the court. We can claim 10 naira. It's actually the court, the breast of the court to say, no, 10 naira is excessive or
no. I'm not thinking about when the claimant resigned.
Yes, sir.
She was sent a letter by the defendant's Exhibit 3.
Yes, sir.
Showing her entitlements, showing her benefits.
Yes, as they understood it.
Yes, and the claimant rejected that, saying that was not entitlement.
Yes.
So since there was a dispute, how is the court going to, determine the entitlement of the claimant?
I thought there were ground rules. I thought there were ground rules by the court. All courts in Nigeria have ground rules that this is what to claim. If a person is this, a person is that, he claims 10 naira, 15 naira. But if the claimant, for whatever reason, did not meet that height or the low, Then
Yes, the court should
being the
shall
arbiter
fill
of
in the
justice,
gap. The court
not
shall fill in the
the-
gap. Eh?
because
Okay.
whatever happens here, sir, my lord has termed it error of counsel. Whatever has happened here, I see it as at best error of counsel, and not error of the claimant.
Mr. Lawrence, we are talking about special damages, not even general damages. We're not talking about general damages, special damages.
No, we made general damages. We claimed them general damages, and we claimed.
Yes, the reason why I didn't give you any general damages is that when the claimant resigned, the defendant sent her a letter saying this is your entitlement, but the claimant rejected.
Yes.
So in essence, it wasn't the fault of the
Defendant.
Yes, to pay. In any case.
Actually, my lord will see from
it's okay.
the handwritten letter. She actually asked for it. They just refused to give her and said she must leave that place. If not, they will not give her. She actually, in the letter, there's a letter before my lord presented by the defendant saying, oh, okay, if this is what you want to pay me, it's less than what I want, but just pay so that I can go and get another place, which thankfully they didn't do. Because if they had, we probably would not have come before the court and she would not have gotten the claim she
okay, what about the house of the official premises that she has been living in?
You see, the challenge, my lord, sir, we actually, yes. It's not actually wholly official.
The claimant.
Yes, the claimant is there, not as if, that's why there's a tenancy agreement.
Yes.
Usually when there is residence, like my lord's residence in Lagos, there can be a tenancy agreement. My lord is there until my lord leaves the
Lagos,
probably to Abuja, which we are praying for. But then, if my lord now, in this case, there's a tenancy agreement saying I'll be taking 5,000, and so it takes a bit of things there. And she had said, which I was expecting. I wasn't expecting much of that.
But after the resignation,
yes, sir.
After resignation, did that tenancy agreement still subsist after she resigned?
No, sir. That's why they now they went to magistrate court. The matter is actually in magistrate court. And they went behind to go and get a judgment that was phony, which we have brought out. But eventually, that's a different matter. That matter is before magistrate in Ogba, in Lagos.
Okay.
Yes, sir. Yes.
Okay. It's okay. Mr. Alamu, are you there?
Perhaps.
Mr. Alamu.
Oh.
Mr.
Alamu is there. No, I think Mr. Alamu has mistakenly gone off. But Festus is supposed to. No, I think Mr. Alamu, it's only myself and my lord that there. The rest of us have closed.
No, they haven't closed. They're muted. Okay.
They are muted. Yes, sir. We are grateful, sir.
Yeah, so
we'll come for the judge and the ruling.
Okay.
When can we come for the
go and meet the registrar? Anytime you go and meet the registrar.
We are grateful, sir. I'm really grateful to have been here, sir. We are grateful, sir.
You can go there maybe tomorrow or next tomorrow.
By grace of God.
Maybe next
tomorrow.
Yes.
Wednesday. By grace of God. All right. I wish my Lord a fine Salah.
Thank you so much, Mr. Lawrence.
Yeah. I'll probably send somebody to collect my Salah meat after.
Okay, meat bar.
Yes, sir. My Lord, I will send somebody to come and collect it.
I should send it to you via Zoom.
No. I don't eat meat from Zoom. I eat physical meat.
You don't want it via Zoom?
No, sir. No, my Lord. I don't.
Okay.
Yes, sir.
Okay.
I'm grateful, sir.
It's okay.
Thank you, sir. Yes.